Welcome to ImmigrationQuestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, ImmigrationQuestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's webinar hosted by ImmigrationQuestion.com, a networking platform and meeting ground where immigrants, families, advocates, and licensed immigration attorneys come together to understand U.S. immigration policies and procedures better. My name is Samia Murat, and I will be your host for today's important discussion, Understanding Financial Sponsorship Requirements in Family Immigration Cases. Family-based immigration is built on proving a qualifying relationship, but more importantly, there is also a financial component that plays a central role in the process. Sponsors are generally expected to demonstrate that they have sufficient income or resources to support the intending immigrant, and questions about income requirements, joint sponsors, household size, and supporting documentation frequently arise during the application process. For families pursuing immigration benefits for a loved one, financial sponsorship is likely one of the most closely scrutinized parts of the case. To help us break things down today, we are honored to be joined by attorney Ngwanda, founder of Ngwanda Law Office PLCC, a full-service immigration law firm handling family immigration, employment visas, investor visas, and deportation defense matters. Originally from the Democratic Republic of Congo, attorney Ngwanda's own immigration journey inspired her commitment to immigration advocacy. She has worked extensively with refugees, parolees, and serves clients in multiple languages, including English and French. Attorney Ngwanda, thank you for joining us today. We're thrilled to have you with us.
Thank you for having me.
Before we begin, just a quick reminder to our audience, ImmigrationQuestion.com is a public educational and networking platform. The information shared with you today is for general informational purposes only and does not constitute individualized legal advice. Whether you're joining us on Facebook, YouTube, LinkedIn, or another platform, welcome. Please subscribe and share this session with anyone who may benefit from learning more about financial sponsorship requirements in family immigration cases. Okay, let's dive straight into it. To begin, what is financial sponsorship in family-based immigration and why is it required as part of the immigration process?
Financial sponsorship in immigration family-based, it simply means that it is a binding legal agreement between the U.S. government with either a U.S. citizen or a lawful permanent resident, and in that agreement, the U.S. citizen or the lawful permanent resident promises to financially support the immigrant family member or the entire family if they are immigrating together.
Okay.
It is a requirement because if that person were to be a public charge, then the responsibility will lie into the sponsor. So that's why they have to sign that type of agreement with the government to prevent the immigrant family to become a public charge. Simply means not to rely on government assistance.
Okay. And who can serve as a financial sponsor in these types of cases, and what qualifications should they meet?
The person has to be, first of all, either a U.S. citizen or a lawful permanent resident, meaning a green card holder, and that person has to be at least 18 years old of age and must reside in the United States of America. That's the requirement that a lot of people miss. You have to reside in America.
Okay. And what documentation is typically required to demonstrate that a sponsor meets this financial sponsorship requirements?
Among other things, the sponsor has to, first of all, prove that they're either a U.S. citizen or a lawful permanent resident. How do you prove that? You have to have evidence of U.S. citizenship. That could be a U.S. passport or a certificate of naturalization for those who are naturalized citizen, or a birth certificate for those who are born citizen. And for the green card holder, proof of residency, which means the green card itself, a copy of it. That's actually the thing that shows that you qualify as a sponsor, because on the document, it's going to show your birth date, which actually is going to lead to knowing whether or not you're 18 years old of age in order to qualify. And on top of it, you have to show income. If you're employee, then you have to show the most recent tax returns, federal tax returns, W-2, and you have to basically show that you meet the eligibility requirement in terms of income, which has to be above the poverty guidelines as described on the USCIS.gov website.
Okay. And how important is US domicile when determining whether a sponsor is eligible to file an affidavit of support?
Well, that's a requirement. That's pretty much so to speak, a critical, important requirement. You cannot bypass that. Of course, there's few exceptions where a person can demonstrate that they work for a U.S. government outside of the United States, their domicile abroad. But those are few exceptions, and you have to talk to an immigration attorney to, first of all, to determine whether you actually meet that exception. But you have to be domiciled in the United States because it's a requirement. And if the sponsor is not domiciled in the United States, regardless of whether the person has a joint sponsor, that joint sponsor paperwork still going to be denied because the main sponsor, the petitioner, is not domiciled in the United States, because that's how important it is as a requirement.
And under what circumstances does a family need a joint sponsor, and what responsibilities does this joint sponsor assume?
The joint sponsor come into play when the main sponsor, the petitioner, has not met the requirement for income, which means that they have low income. It doesn't meet it's not above the poverty guidelines, federal poverty guidelines as described on USCIS.gov website. Or let's say they have their employment history is not, we can't verify that, or they're self-employed, but in a manner that does not sustain themselves. So we can't really determine whether or not they meet those income requirements. So meaning that they don't have enough money. Then the joint sponsor come into play. The joint sponsor has the same responsibility because it's an agreement. It's a binding legal agreement. They have the same responsibility. They are promising to financially support the immigrant so that the immigrant does not become a public charge. It's the same responsibility. Yes.
Okay. And for families preparing to file a family-based immigration case, what practical guidance would you offer regarding financial sponsorship and supporting documentation?
First of all, we have to, when a person is filing a family-based type of petition, when it comes to sponsorship, we sit down with the person, we determine, first of all, if they meet the requirement, meaning what? Meaning how many people in the house, basically the household size, based on the number of the people in the house and the number of the people they're sponsoring, or if they've sponsored anybody else before, then we will determine whether or not their income is enough. If their income is enough, then yes, we'll go with their income. Then we ask that they provide the most recent tax return, W-2. To some extent, we might also ask for somebody to show their last 6 months pay stub if they just started working, and the employment verification letter if they just started working, right? If they haven't filed the tax return yet. So after that, if still the money is not enough, then we can look into assets. If they have assets, we might determine whether the asset is sufficient in order to meet the requirement. If not, that's when we ask for a joint sponsor. And the joint sponsor too has to show, again, proof of eligibility. We start with proof of citizenship or lawful permanent residency. If they are lawful permanent resident, then we go to the income as well. Tax return, W-2. If they happen to be self-employed, we go with the 1099. Anything that shows that the person is eligible, as we already talked about the eligibility requirements. And then after we gather all those documentation, that's when we can determine whether or not the person actually qualify for sponsorship.
Okay. For everyone watching, this conversation about financial sponsorship is intended to shed light on one of the key components of family-based immigration questions. Questions about income requirements, supporting evidence, and sponsor eligibility can come up at different stages of the process, and access to accurate information allows families to approach the requirements with a much clearer picture of what should be expected. If this is your first time joining us, welcome. Immigration Question is a networking platform where users can ask immigration-related questions at no cost and engage with participating attorneys. We're also proud to share that Immigration Question is BBB accredited and ISO certified, reflecting our commitment to transparency, accountability, community education, and security. Now, attorney, based on your experience, how does immigrationquestion.com help immigrants and immigration attorneys like yourself?
Well, it's immigrationquestion.com provide a platform where professional expert come to answer questions. And for me personally, as an attorney, it provides me with the visibility that is needed in order to be in touch with clients, prospective clients, so that first they can learn about me personally, and they might be able to know what type of services I'm able to provide, what are my credentials, and for immigrants, they're learning more about what's going on in our environment with the immigration states, what mostly what not to do, just general information. It's crucial to know that prior to engaging in anything that might affect people's future. It's important to be informed. So that's how I see immigrationquestion.com.
Now, before we move into our live Q&A, let's just tackle one more important question. What are
Mhm.
some common misconceptions about financial sponsorship requirements in family immigration cases that you believe should be clarified rather, to avoid misunderstanding?
People should know how long they're supposed to stay. Like, for example, if a person decided to become a sponsor, they have to understand the depth of their responsibility and the liability that comes with it. So you become a sponsor, you're sponsoring a person. It doesn't just end like with filing the paperwork once the person get the green card. So you're still responsible for that person, either until the person become a U.S. citizen or until the person earn it's called 40 qualifying quarters of work, which means at least if the person has worked for at least 10 years and they qualify for those 40 quarters. How do you know that? You have to talk to Social Security income, that they will give you the specifics on how they determine whether or not the person has qualified for those 40 quarters of qualifying work. Whether the person just permanently leave the country, or if the person passes away, that's when your responsibility ends. Other than that, you're responsible until the person becomes a U.S. citizen.
Okay.
So yeah, you are responsible. Yeah, you just have to understand that I'm signing this thing and I'm responsible until the person becomes a U.S. citizen. If the person doesn't become a U.S. citizen, then you have to find out whether the person has worked for at least 10 years and they qualify for those 40 quarters of qualifying work. You have to talk to Social Security to determine that. Yeah, or the person has passed away, then you have proof of that, then yes, you're no longer responsible. Other than that, you're still responsible. So that's something people have to know. Sometimes people, they just think like, okay, I sponsor them, they sign, they got the green card, I'm done. No, you're not done yet. And if
Okay.
that person goes and get medical treatment, for example, or go and get something from the government, and the government is trying to recoup their money, and the person is not able, then you will be responsible for paying back that type of money, because that's the agreement you sign, to financially be responsible for that person.
Okay.
Yeah.
If you're just joining us, we're speaking with immigration attorney Gwanda on understanding financial sponsorship requirements in family immigration cases. We're now going to move into our live Q&A session, and this is your opportunity to ask questions and hear educational insights from a licensed immigration attorney. Please drop your questions in the chat, or you can call us live at 516-703-3483, and we will take as many questions as the time allows. Okay, question number 1. What happens if USCIS says my sponsor does not make enough money to support my case?
Okay, if USCIS determine that the sponsor does not meet the requirements, what they'll do, usually they'll send a request for evidence letter explaining why they think that your sponsor does not meet the requirement and what to do. And most of the time, they will ask you to bring a joint sponsor. So that's when you have to go ahead and find a joint sponsor. A joint sponsor, meaning the person must qualify as well, U.S. citizen or lawful permanent resident, must be at least 18 years old of age, must reside in the U.S., and also must meet the income requirement. And sometimes too, you might be able to join a member of the family. That's like you sign another contract between the household member of the family who's trying to support with their income as well. And that has different requirement as far as how to meet the income requirement eligibility.
Okay. Question number 2. Can a family member or a friend help sponsor me if my spouse's income is not enough?
The simple answer is yes, if they meet the requirement as well. First of all, the petitioner still has to apply by filing the form I-864. Then the family member or friend has to file again the form I-864. As we said before, they have to meet the requirement as well. Must either be U.S. citizen, lawful permanent resident, must be 18 years old of age, reside in America, and meet the income requirement. It has to be above the poverty guidelines. That's just, you go on USCIS.gov, you can refer to the guidelines as far as household size is concerned.
Okay. Question number 3. How much money does my sponsor need to make for USCIS to approve my case?
That's case by case basis. For the simple, let's say the household size, it's let me look at USCIS.gov. You just have to go on USCIS.gov, right? The way it works, poverty guideline. Let me see here. The exact amount, you have to go on the USCIS.gov. For example, it says for households of if the household size of two, 120, the money has to be 120% above poverty guidelines, which is 27,050 a year. That's for the two people household size. But the thing is, you really have to go on USCIS.gov to really look at the number of the people in the house, including the person you are sponsoring, to make sure that the person meets the requirement. So it's something that, yeah, you really have to be able to read it correctly.
Okay.
Or you can consult with an immigration lawyer to help you with that form as well. That's another option.
Lastly, what happens if my sponsor loses their job while my case is still pending?
Oh, yeah, then you're going to have to get a joint sponsor. Yes. Because the case is pending, the sponsor loses the job. And by the time you go to the interview, you have to tell the truth, because you cannot misrepresent facts. If the person is not working, then the person is not able to sponsor. So you have to get a second sponsor. That's it, a joint sponsor.
Okay. Now, recent reports indicate that ICE has launched a new sort of crackdown targeting alleged birth tourism networks. So, attorney, could increased scrutiny of visa misuse affect how consular officers evaluate non-immigrant visa applications, and what should legitimate applicants keep in mind when preparing for their cases?
Okay, if you're preparing to come to the United States, one thing people have to keep in mind is the fact that on January 24, 2020, the Code of Federal Regulation, that's the law, it was amended, okay? It was changed and amended, and they added some terms and explanation of what actually pleasure means, right? So when it comes to B1 visa, B2 visitor for pleasure, people used to think like pleasure, I might get here for the purpose of giving birth to my US child, that constitutes pleasure. But the Department of State has clarified that, and the regulation has been amended. Pleasure does not include travel for the primary goal of giving birth to your child for the purpose of obtaining US citizenship. So if the person is pregnant, there's already a presumption that when you come in here, your intention is to give birth here and to acquire US citizenship for your child. Then if that person later on, of course, they get here and then they get pregnant and the child is born here, that person visa is going to be revoked and that person will be banned. That will be a permanent ban. So this is something that has already been stated. It's not like ICE has come up with a new thing. It's in the law. They're just implementing it now and trying to basically investigate on those agencies that are facilitating those type of fraud, so that people should be aware that when they're coming for visit, the intention is to visit, tourism, and to go back, not for the sole purpose of giving birth to a child for the purpose of obtaining US citizenship for that child. That will be those type of people will be really prosecuted because now it's in the law. So it's something people have to keep in mind.
Thank you to everyone who joined us today for the seminar, and thank you to Attorney Ngwanda for sharing your knowledge as well as your practical guidance. You can always visit immigrationquestion.com to ask immigration-related questions, to stay informed about policy updates, and to register for upcoming live events. If you've missed any part of today's discussion, the replay will be available on Spotify soon. Search Borderless Talk by immigrationquestion.com. We look forward to seeing you on Friday at our next live session. Stay informed, stay prepared, and stay connected.